Hey yo, and good morning, everybody in the United States. It's 9:20 in Georgia, and let me get rid of that. Um, yes, this hearing is one for mother's contempt of court. For you who doesn't know, she was discovered taking pictures in the courtroom. That's a bad idea. And she was discovered doing it, and so they scheduled a contempt hearing for today at 9:30. And I would assume it is the judge scaring her up a bit and then give her a small fine of sorts. But then again, we don't know because she was discovered taking pictures of at least one picture showed some of the jury. And so that kind of, so to speak, elevated a bit, but you never know. But according to law and crime, sentencing hearing. And then I remember that they scheduled for the same day in cahoots, not in cahoots. They decided that they would have the prosecution either move for sentencing or yeah, uh, I know I cannot hear in the background, but the judge if they will move forward with the sentencing of counts 6 to 8, removing of gun, removing of car, and tampering with evidence, or if they will move forward, if they choose to take the third stab at. And we learned that Georgia has is that it's a time limit when you have a speedy trial. That if there is a third failed attempt and a mistrial, then is this better? I changed microphone to the webcam. Okay, I changed from this to webcam sound. Apparently that worked. Okay, but I still need to hear the court. Removing that part so I can hear the court. Yeah, I unplugged it and plugged it in again. But that didn't work. I don't know what's going on. And yes, I know that law and crime is up, but they are not supposed to start yet. Okay, now with with sound. Now with sound, and oh, Look at that. Hi, Mo.
Hello. I didn't even remember today was Wednesday.
Me neither. The I was just on YouTube's, and all of a sudden, Law and Seaward stream came up, and then oh yeah, that is today. Uh, yeah. So today we will learn first what happens to the mother for taking pictures in the courtroom. Then we
Yeah.
will, yeah, and they scheduled the so-called sentencing hearing at the same time,
Oh, yeah.
which is a two-part decision. The prosecution can choose to move forward with, as I interpret it, move forward with the sentencing of counts 6 to 8, which also means that they give up on the trial. But they can also choose to take a third stab at trial. And for if they choose a third stab and it becomes a mistrial for a third time, Georgia speedy trial rule says, yeah, that's it. You can't, because I think they have until the end, first Monday or Tuesday in December to have the trial. And even if they choose a fourth trial, it has to be scheduled, it has to be everything, and they simply don't have time for it. Since between first retrial and second, 4 months. So if they choose a third, then the third attempt will be in maybe 2 or 3 months' time at the fastest. No sound. Muted. Muted.
I'm torn because I see this prosecutor being very tempted because it went from being 6 to 6 to 8 to 4. So I see him being very tempted by that, but I
Mm,
also see him running up against that deadline and, people at his office saying, "Are we going to expend more energy on this when we have, I'm sure,
mm.
other crimes that are in the pipeline?"
Yeah, exactly. That would be every day, every time they try this, every time they try him, they are choosing to not move forward with something else because this it it takes time to set everything
Yeah.
up, to have new hearings, to have the trial. So it takes up a lot of the court's time to even move forward with this. Oh, 2 hour delays for teacher professional. What is that?
That is the union being pissed off we wouldn't pay teachers more, so they finagled a 2-hour delay every Wednesday,
Mm.
because I hate our teachers union. I mean, I love our teachers union. They do a great job. Why
Mm.
have instruction time in school?
Mm. Sentencing for counts 6 through 8. That those were the he was convicted in the first trial for counts 6, 7, 8, which was uh, removing of a gun, removing of car, and tampering, evidence tampering, or tampering with a deceased. No, tampering with evidence. So those three charges he was convicted for in the first trial. And so they retrialed counts 1 to 5. But since those three that he was convicted of, they can't sentence him until the actual trial is done. Counts because it has to do with sentencing. Because if he is if he was convicted of everything, then it counts into the sentencing. Oh, my alarm bell saying, "Oh, now it's the time." Can you speak for a moment while I take care of this,
No
please?
problem. Um, so yeah, I see this. I hope they let it go, Indigo. Hey, Sal. Yeah, crazy by proxy. A lot of their schools do like a 30-minute once a week. I don't know. Our school is crazy, our school system, so I have no idea who came up with this. Um, what I do see and what I know is that I think all of the charges that he is possibly being charged with today, I believe that his time served might cover those particular charges. So I really hope that he just gets out and possibly this has taught him a lesson. It looks like he's gotten married and maybe he just straightens up and flies right. But
Yeah, take a job that suits his level of smartness. And
and
yeah,
stays away from his mom. Good lord.
oh yeah, oh yeah, we know where he got his smarts from. Uh,
Oh
Taking
gosh.
pictures in the courtroom. No, that was a really, really bad idea. Uh, yeah, and well, there are a bunch of new people here that weren't here the first 5 minutes. Hi, everybody. Uh, we are here for the mothers, Austin Ford's mother's contempt hearing, and possibly sentencing. And as I started to say, I don't know if I finished it. He's convicted of counts 6 to 8. They retried him for counts 1 to 5. And if they decide to take a third stab at it and fail again, then he walks on everything because it's all in one trial. So, if I would suggest to the prosecution that cut your losses,
Yeah.
don't waste anybody else. Because I saw that well, 8 to 4 is far away from 12. Yes, it is. But then again, in the great state of Florida, 8 to 4 in sentencing is enough to kill someone. So, and in Georgia, it might not even be enough to an actual conviction. And it isn't enough for a conviction. It's hung, and it shouldn't be anything else, in my opinion.
And Austin, move, because that mom has it out for you, sir. Keep your head on a swivel.
Mm.
Move out of state.
Rehabilitated thugs, you can count them on one hand. If you have a fork ton of fingers, and how that I'll compare with the Scandinavian systems that is still moved forward to moved towards rehabilitation, and first-time offenders has a rehabilitation grade of up towards 85% here. That will never commit another crime in their life. Now, when it comes to gang members and such, quite a bit lesser. I believe it's the other way around.
Well,
But
and I think
thugs do get rehabilitated, because if we give up on rehabilitation, then what? We have a thug that spends 4 years in prison, learns nothing, and then walks out even angrier than before. That's not, in my opinion, that's not good. It's happening with Harper. Whose mom took pics in court, and why did she? And also, how did the court find out? Austin Ford's, the defendant's mother, took pictures in court. Why? We don't know. We might hear it today. And how did the court find out? Well, she was discovered by either a bailiff or a court officer. So, yeah, really, really bad idea. 8 to 4 will be overturned on appeal. Yeah, in Florida, yes. 8 to 4 will definitely be appealed, at least. Because I think it's Alabama who has 10 to 2 to get someone the death penalty. but Florida said 8 to 4, and yeah. I have this strange buzz in my ear from the court. I don't know if you hear it, Mo.
I'm not hearing it, but it might be your, I
Yeah,
I don't
it,
know. I'm not
it
trying
might
to
be
give
my
tech
earphones.
advice. I in no way give tech advice. Like, if you've turned it on and off, that's about my level of tech adviceness.
Yeah, it's weird because it has happened before, and I don't know why. Yeah, I'll have to deal with it. Most thugs get rehabilitated with age, turning 40, and most people calm down and find another lifestyle. Yeah, or if they are really bad, they might not
Yeah.
survive to 40.
Well, that's the thing. I think there's that like 11% that just are gonna be asses no matter what. And you need to
Yeah,
separate that 11% that are just going to choose wrong no matter what. Like they could have the best life, the best parents, just gonna choose wrong.
yeah,
Those are the people we need to send to Snake Island. You know,
mm,
you just can't be a part of
mm,
society. The rest of
yeah.
the people you can,
Mm. And even with those 11%, first crime, slap on the wrist. Second, third, fourth, okay. Then the bundled up. Now you're away for 2 years. They come out, do more crimes. Okay, 10 years. If they don't pass away of unnatural causes, they will come out madder, commit a new crime, and then they will be going away for life. Here's the thing: we don't know who they are from the beginning.
no,
That's why
that's
we
the
have to
thing.
give the benefit of the doubt in sentencings, because most people who are sentenced for a crime will not do crime again. Mm. Yeah, some, especially yes, I don't know enough about the U.S. System, but for me it sounds like when they are sending off kids to juvenile, I mean 14, 15-year-olds with 17-year-olds, they learn how to crime better or worse, more than they get rehabilitated in juvie. How to Hi Brandon. First offense, you shipped to Australia.
How are we gonna send them to a made up place? The premise is wrong to begin with.
uh, Rose-colored glass, maybe, but also statistics. So, and if the statistics says that most people who are after their first sentence will never do a crime again, who am I to disagree? Hi Fedretzky, good to have you. I saw Medida Fin earlier. This way up is here. Yeah, good afternoon here, and good morning in the United States, and I think it's already tomorrow in Korea and Japan. So yeah, we are waiting for the court to start. It was scheduled to 9:30 Georgia time. Or
Yeah,
no,
I mean, and this
8:30.
is odd because
8
she's
8:30.
usually fairly.
Yeah, she is on time, but
Now,
not today.
I will say if we had a program, not conscription in
Mm,
the general sense of military service, but some sort of
mm,
civil sort of you had to do something for your community, a year-long, almost pre-adulting, you had to go do community gardening. This
mm,
is how you adult. This is how you change a tire. This is how you balance a checkbook. This
mm,
is how do all these things, grocery shop, make a meal plan, that kind of
mm,
thing. You know, stay healthy. Because I think a lot of kids are growing up and they either the parents don't they didn't have parents to teach them that, or there's
mm,
a lot of people growing up and they just don't have a direction. So you get
mm,
it was kind of
mm,
sad because on the Wild Bill, victim impact statements, if the mom hadn't been in her formal, or grandma hadn't been in her formal tank top and Daisy Dukes, I mean, she was making cogent points, you just really couldn't get past the whole swap meatiness of the thing. There are a lot of kids that are turning to crime for that false machismo and okay, fine, your bank,
mm,
your finances. But,
mm,
if you had people that were going to show you how to do all these things,
mm,
so you weren't kind of lost, I
mm,
think that would be helpful, but I'm just a person on the internet who has way too much Sailor Moon
mm.
stuff.
Free trade school for criminals. It's in Swedish prisons, they can also choose to have get a degree or read up on their normal grades, so that they later on can go move on to university or and according to statistics, and this I learned from watching Andrew Branca, is that single person households have a higher chance overall. But if there is a good male father figure or a good male figure involved, then the risk of criminality less is way down, the risk
Yeah.
for crimes. And even so, in prison, if they get a good male role model, I don't know why it is a difference between male role model or female role model, but statistics, I can't argue with that. I don't care if it is politically incorrect. It's just a difference. With a good role model, they can and often will get out of that way of doing bad stuff. And yeah,
I
YouTube
sentence
things.
everyone to have to watch Major Payne.
Mm. Yeah, and do all the YouTube things, like on your way in,
Yes, please.
subscribe and stuff, and then move over to Mo in the Deep End and subscribe to her and like everything she has done. And we are still, I'm checking Georgia time, 9:43. So yes, they are still a bit late. I'm I have this in the background, so I'm ready when they are doing it. Still a bit surprised. I would assume that the judge, would be on top of it.
Unless they're doing, sort of behind the scenes or closed motions, something of that sort.
Yeah, that would still be in court. Um, yes,
Maybe the mom didn't show and they're having to do a bench warrant. Please let the
I'm,
mom wild out. I know it's terrible. I know it was not a good thing but I need mom to act full on ratchet just for my amusement, which is terrible because I am a horrid person.
okay, while we wait for this one, what's happening next on your channel, Mo?
Well, I am gearing up. So, as you know, the little people are going back to school. So, I finished up with the Wild Bill case. I am gearing up to do some Futurama reviews because I'm a big nerd and they have come up with some new they're starting new series, so I
Mm,
will be reviewing those. I am going to do a tribute. I did a sort of small one on my craft stream, which will be going up on Sundays. I will be doing cross stitch streams where we just kind of gab and talk. But I'm going to be doing a tribute. The voice actor that did the voice of Dale Gribble on
mm.
King of the Hill passed away. So I will be doing a
Oh,
tribute video to him. And I have just a couple different videos, and then I will be diving into the Karen Reed case. Now, that is huge enormous, so it is a lot.
Mhm.
Um, so I will be going into the turtle guy, and he has about 90 bajillion pages of things, so pray for me now and at the time of my oh my godness.
Mm.
So,
Okay. Uh, for me, uh, this morning or late last night, my time, and I found out or discovered that the Young Thug RICO trial. I've been covering that for a few months. Uh, that district attorney is the district attorney that is doing the Trump RICO. It's the same district attorney.
oh dear Lord,
Yeah.
please
So,
let her bring in the photo guy.
so
I need
yeah. So I will be doing a stream later today. I haven't had the time figured out yet, where I give my honest opinion. Now, for you who don't know, hi, I'm a union rep. I do labor law, which would put me in the lefty kind of political way by US standards, in the middle of the road Swedish standards. But yeah, I have questions, especially since she claims she can get that to trial within 6 months.
I do have some questions about that. When is giving legal advice illegal? So when is acting like a lawyer, acting as a lawyer indictable? Because
Hmm.
I'm
I I would assume that maybe a US lawyer would be better to answer that.
okay,
Uh,
because well, and then like Kanye's finance person. I mean, look,
mm,
Kanye's done weird things. I mean, he promoted the Kardashians.
mm.
I mean, he tried to do Bohemian Rhapsody. There are things that he has done.
Is it a good or a bad thing for Trump? Uh, both. She has experience in doing RICO. This is not her first RICO trial. She was appointed DA in 2021, and I think the Young Thug is her third RICO already. And
She's doing
so,
a wonderful job. It's only
yeah,
been like what, 8 years and 900 hours of Dolbert hearings.
yeah, yeah, yes, she wants to try all 19 of them at once on RICO charges within 6 months. Yeah, all 19 of them will have their own counsel. They will all send in their own motions. They will all send in their own objections. They will all send in, I mean, these, and these things take time. You can't just say to a judge, I need this done within 6 months, because that judge has a scheduling himself or herself.
Well, it just
Hmm. Yeah,
the more these go on, the more even normies are waking up and saying, "Okay, on a good day, I'm one of these people in the middle who cares very little about politics, but this does seem a little fishy." So I think
yeah,
people who are on both sides of the very end of the spectrum screaming loudly, "It's unfair," are
mm,
waking up the middle people that are like, "The hell is going on here? I
mm,
just want to be left alone and watch YouTube, with the weird, oh gosh, horse farrier people that cut hooves and, they explode with pus because for some weird reason we got on that." Yeah.
mm,
People are like,
yeah,
"I just wanna be left alone," and all of a sudden, Trump's indicted for, like, 90 bajillion things? What's going on here?
yeah. And from here, from across the pond, I thought I would just sit back and enjoy the show because, yeah, it doesn't really affect me. But then I found out, oh, it's that DA who wants to use those experts. Oh, oh, oh. let's see here.
Well,
There
and you
are
have. Are they
doing
finally
some.
coming in? Judge Sassy Glasses going to be there?
Okay, here he is. So
All
we
right,
will
good
find
morning,
out now.
Mr. Norris Lewis. If you could just call the calendar, please.
Now we will find out.
I believe the first matter on the calendar
I'll call it if you don't have it.
is, well, both matters on the calendar relate to case 23B00981-3. The first matter is a contempt hearing against Ms. Sheila Holly, and she is represented by Mr. Lamar Smith. Mr. Smith was present. I believe he had to go down to the second floor to check into a courtroom between when the court first came on the bench and now. But I expect him to return shortly.
All right, we'll hold for him on that, but I intend to go forward on the other matter first.
It's 23B00981-3, State of Georgia versus Austin Tybee Ford, before the court for status and/or sentencing.
In the state's position,
Your Honor, with a heavy heart, this state is announcing that it is not going to proceed with a third trial on counts 1 through 5 in the State of Georgia versus Austin Tybee Ford, and the state is asking that he be sentenced on counts 6, 7, and 8 after being duly convicted of those matters at the conclusion of the first trial.
For grifting purposes,
right,
I'm sad,
Mr.
but for
Lawrence
Mr.
Lewis,
Ford,
on behalf of
I'm
Mr.
good.
Ford, are you prepared with that announcement to go forward with sentencing this morning?
Yes.
All right. The first jury having reached a unanimous verdict solely as to count 6, 7, and 8, count 6 being theft by taking, count 7 being theft by taking, count 8 being concealing death of another, and the court having declared a mistrial as to counts 1 through 5, and a second jury having heard evidence in the case and being unable to reach a unanimous verdict on counts 1 through 5, the court is left with sentencing solely as to counts 6, 7, and 8. I will hear first from the state with any evidence in aggravation and any other relevant evidence you want to present with regard to sentencing.
Your Honor, the state does not have evidence in aggravation in as much as this defendant did not have a prior criminal record. There are victim impact statements, 4 that I expect will be spoken if the court would like to take them now or after any evidence in mitigation is given, as well as the state does have a recommendation.
Okay.
Your Honor,
let me hear the recommendation in first, please.
Your Honor, the sentence range for counts 6, 7, and 8 is each 1 to 10 years to be as the court sees fit. The state is recommending a sentence respectfully of 30 years and that to be served in custody. A sentence of 10 years on each count to be run consecutively to each other. The state's position and the reason for that understanding that he was not convicted of counts 1 through 5, that the theft of the vehicle, the theft of the gun, and concealing the death of another in the manner in which it was done was concealing the death of Tory Lang, one that, by his own admission, he at the very least was aware of. This defendant spoke with her family members. He went to her funeral. He initially contacted Tory's mother, and when he knew what had happened to Tory, when Tory was just missing as far as the family knew, when he knew what had happened, he said nothing. He pretended to look for Tory. He pretended to be a concerned friend, knowing that he disposed of the weapon that she was killed with. He disposed of her vehicle. He continued.
Yeah, they failed twice. to get guilty of murder, and now they are trying to get as high of a sentence as possible to, in his opinion, maybe balancing the scale. We couldn't get him, but please sentence him for 30 years because we don't give us something, Judge. We don't like losing, but give us something so I can get reelected.
To conceal any knowledge about Tory's death until he was finally caught in a number of lies by Detective Carter, but not till months and months later. This is having talked to her mother on the phone after having gone to her funeral, after having pretended to be someone who cared about her and was concerned about the family's grieving. It is malignant and heinous to behave in that manner, and thus add to the grief and to the wrong that has been done to the Lang family. So the state does respectfully ask this court to sentence this defendant to the maximum possible sentence and ask that it be served in the custody of the Georgia Department of Corrections.
Okay, 2 questions. Is a 30-year to serve sentence in line with what the state would normally ask for these 3 charges for someone with no prior criminal history? I mean, is that in line with what you would recommend
Uncle Phil's going to say yes.
Somebody has been convicted of these charges?
Yeah, exactly, because he is trying to push in counts 1 to 5 into the sentencing of counts 6 to 8. Here's the thing. Innocent unless proven guilty. And if 1 to 5 is gone, then the only crimes he committed was those 3.
Under these circumstances, yes. He's
though
not convicted of being the direct perpetrator of her death.
Nor can I sentence him for that.
And I'm not asking you to.
Yes,
because
you did.
Yes, you are.
The jury has spoken. They were unable to reach a verdict. 2 juries were unable to reach a verdict on that. And the state's not asking this because it could not secure a conviction on the other counts. But the state is asking that you consider the level of grief and strife that was visited upon the Lang family by this defendant based on the offenses even for which he has been convicted, and how not knowing knowledge of her death and knowing that a close friend of hers had knowledge of her death,
you shouldn't,
at the very least, for months, and
even
failed to share that with them and allowed them
I
to
smell shite.
At least 2 days not knowing what had happened to her at all, then to find out that she had been shot in the head and he left her in Yellow River Park. And that is what he is convicted of. And I do believe that the sentence the state has requested is appropriate based on the facts and circumstances here. Obviously, each recommendation made by the state is made considering the entire body of facts and circumstances. And though he has no prior criminal record, that does not mitigate how heinous his actions actually were and how they impacted the Lang family.
All right, have you prepared a null pros for the court on the prior indictment 22B03732-3?
I will provide the court with one, yes.
All right, that will need to be provided today.
Yes, Your Honor.
All right, let me hear from Mr. Lawrence Lewis. Do you intend to call any witnesses?
I'll probably go call some witnesses. I don't know if you want to hear me speak first in terms of an argument or just hear from the witnesses. I mean, it's a close preference.
Let me hear from your witnesses, and then I'll hear from your argument. And by witnesses, that would include Mr. Ford in the event that he wishes to speak as well.
I apologize, Judge. No sooner than I say that, but let me say something because I think the court's going to have to think about something while the court hears the witnesses. I know the court can do 2 things at one time. So let me just say this first. Judge, my client was convicted of counts 6, 7, and 8. He wasn't convicted of concealing the death of another. He was convicted in count 8 of tampering with evidence.
No, you continue to refer to the first indictment that charged him with that. The second indictment for which he was actually tried, count 8 is concealing the death of another.
I got it.
let me read the language in there. In that particular indictment.
He was so good with the mic in the trial, but
Got it. Judge, ultimately,
Nope.
6, 7, and 8, I think exactly carried the penalty that the prosecutors outlined, 1 to 30. I'm going to be asking the court to consider a sentence of 10 to serve 2, which I suspect is what is in line with what the state would recommend had we not had 2 hung jury trials. What the state is asking the court to do right now is sentence my client to 30 years in prison, 10 plus 10 plus 10. The difference is on that 30, obviously he would be eligible for parole because none of those are mandatory minimums. Ultimately, if my client had been found guilty of any sort of murder charge, felony murder, the court would have to give him a mandatory minimum sentence of 30 years. And that's exactly what they're asking the court for today, 30 years. I always love how the state says in every trial, we love our burden, we accept the burden, but they don't really accept the burden. It's almost as ridiculous as when they say we love speedy trial demands when they're twisting in the wind and emailing me 1,000 times when I'm on trial about this speedy trial demand. It's just not true. Just tell the truth. They're asking the court to sentence my client to 30 years, which is exactly the sentence that the court would have to give him. The court would have to give him life if he was found guilty of murder. And life in Georgia is 30 years before you're eligible for parole. Obviously, life with the possibility of parole might mean that he might be denied parole at 30 and then come back up at 36, 42, 48, 54. In typically periods of 6 to 7 years, parole circles back around and considers parole again. But what the state is asking the court for today is basically to sentence him as if he had been convicted of the murder charge. That's clear law. Life in Georgia means 30 years before you're eligible for parole. The only difference between life being eligible for parole at 30 and you giving my client 30 is that he would be eligible for parole much sooner on the 30 because it's not 30 to the door because there's no mandatory minimum. Other than that, Judge, there's no factual difference in ultimately what the prosecutor is asking the court for. So I'm gonna respectfully, Judge, argue that the sentence that would be more in line would be something that would sound like 10 served 2, and obviously I would argue that my client should get credit for time served. And I'll call his mother as my first witness on the stand, Judge.
Oh, no, don't call the
Oh, no.
mother.
Take the witness stand for me, please. And Mr. Smith, are you present on behalf of Ms. Holly for the contempt hearing?
Yes, Your Honor.
All right, and we'll address that after sentencing. They're both related matters, but I'm going to address sentencing first to give Ms. Holly a chance to speak on behalf of Mr. Ford.
You know the time I have a calendar and judge.
I'm happy to let her know you're here with me, but I can't excuse you.
actually,
I will
because
email her now. Just give me a moment.
her judgment might be not the best.
Give me just a moment.
That's fine.
Yeah, the prosecution simply, we couldn't get him convicted, but please give him 30 years because I want to be re-elected. That's
Yeah,
just
it's
stupid.
exactly what you would
Yeah.
do to
Mm.
other people.
And 10 years, I think that's a bit much. But to
All right,
serve,
please
yeah,
proceed.
maybe.
Thank you, Judge. Raise your right hand, man. You swear affirm the testimony you present this morning in the cases State of Georgia versus
Austin, type brief forward will be the truth, the whole truth, and number the truth, so help you God.
Yes.
All right, you can put your hand down. State your full name.
Sheila Holly.
All right, and your relationship to Austin Ford?
I'm his mother.
Okay. Prior
he
to
was a young
Austin being
mother.
locked up, did Austin
Became a
live
mother
with
at a young
you?
age, I would assume.
Yes, he did.
Okay. Has Austin lived with you most of his life?
Yes.
Is Austin your only child?
No.
Okay. How many other children do you have?
I have one older son.
All
older
right.
Austin.
Meaning, of course,
One
implicitly that
older?
Austin is your youngest son. How old is Austin?
Austin is 22.
Did Austin graduate from high school?
No, he didn't.
All right. Do you remember what high school he was in when he did not finish high school?
He was in Stevenson High School.
All right. What grade did he complete all the way through?
He completed the 10th grade.
10th grade. And in 11th grade, did he leave school?
It was COVID time during the 11th grade.
Okay. So 11th grade was one of those times where he may have done some online schooling for a bit?
A little, yes.
Okay. Did he ever return to school after COVID?
No.
All right. Do you know if he's earned his GED or high school equivalency yet?
He was going to Job Corps. We were waiting for Job Corps to be back in session, but COVID started. So he was on his way to Job Corps.
Okay. Does he have any children?
No.
Doesn't have any children. Who's here in the courtroom in support of Austin Ford? Who's here?
His pastor, who also was his football coach from since he was 8 years old,
Okay. And his name?
is Pastor Shelley.
What do you want the judge to know about Austin Ford?
Austin has a generous heart. He's actually an empath, very spiritual. He assists all his friends. I had to really instill in Austin that the way he looks, he needs to tame it down because his appearance may be intimidating to other people. And he just may look like other people that, do indecent things. So I really had to instill in him that, he really have to show up and really be himself, show the nice guy that he is. And that's what he do. He helps all of his friends.
I don't have any other questions. The prosecutor, he may have some questions for you.
Yeah, that
Questions
empath
from the
thing is
state?
going to fly.
Ma'am, you can step down and return to
Your
your
choice,
seat.
prosecution. You don't want to look like the a-hole you
Generally are.
10 minutes ago. Oh, pass it.
You can have a seat. Raise your right hand. Do you swear affirm testimony you provide this morning, case the state of Georgia versus Austin Ford will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes,
Okay, you can put your hand down. You and I haven't spoken before today, have we?
not at all.
Okay, yeah, and because I'm rushing from another courtroom here and I'm late for this court, you and I
I'm
didn't get a
sorry.
chance to talk this morning.
Have him state his name.
Yes, what's your name, sir?
Yaku Shelley, Senior.
Okay, give me,
Spell it for us, please.
Yaku is YAQUIS. Shelley SHELLEY.
Thank you.
Senior.
thank you very much.
not
So you and I didn't get a chance to talk because I was running late this morning. I've called you to the stand. I promise you, every question I ask you, you're gonna know the answer to, all right? Have you testified before?
Ever?
Ever?
Yes.
Okay, fantastic. Take a deep breath. If you don't understand the question that I'm asking because I'm talking too fast with my Jersey accent or something, just let me know and I'll rephrase the question, okay?
Yes.
What is the role that you played in Austin Ford's life?
Coach, I initially met Austin. His mom brought him to Central DeKalb to play youth football.
Central DeKalb at what age?
We met Austin around 10 or 11.
He was 10 or 11 at the time. Okay. And when was the last time you coached him in football?
12 years old.
12 years old. Okay. So when he was in high school, you weren't doing any coaching.
Not the coaching
Okay.
piece.
Okay.
Yeah.
That's fine. Did you ever go and watch any of his games? Did you sort of follow what was going on with his football in high school?
Yes. During the football piece, they end up coming to the church. So I've been around Austin for 12 years.
Okay. Post high school, Austin also played some kind of football?
No, not post high school.
No.
He just attended the church.
Okay. I got you. Did you follow any of his football career after high school?
Not after high school.
Okay, that's fine. When was the last time you physically seen Austin in person?
Outside of here, the last trial was the last time I saw him. But you saying outside of
Outside of this process, that's correct, sir.
probably about a year ago.
About a year ago.
Over a year ago.
And when you saw him in what capacity? Where was he at? How did you sort of see him?
He came to service. He had a young lady with him.
Where's your church at?
Right off Austin Drive behind Quick Trip, right at 285 Covenant Highway.
Prior to COVID, how often would you see, I'm assuming COVID impacted your physical attendance at your church, did it not?
Yes.
Okay, I anticipated that. Prior to COVID, how often would you see Austin? How often would Austin come to church?
Regularly. I can't say if he was there twice a month or every Sunday, but I would see him on a regular basis.
He was a regular fixture. And was he participating in anything at church, youth ministry, men's group? Was he participating other than, say, church service on Sunday or church service on Wednesday night?
I wouldn't say that he was active in a particular auxiliary. I wouldn't say he was in the auxiliary.
That's fine. Did you ever tap Austin to do any special projects? That's always what scares me about church. Hey, I need you to do this, that, and the other thing. Had you tapped him for any special projects? Hey, I need you to work with the young people. I need you to do
Mr.
something
Mo
else
made
when you're at the church.
the terrible mistake of
can't
letting
recall
church know
doing-
that he knows how to do contracting stuff.
Oh, bad idea. Really bad idea.
Terrible idea.
Oh, really? Can you do that? Here's the job. Yeah.
The pastor has him on speed dial.
Yeah.
We share custody.
Mm.
Anything
Okay.
extra outside of
Okay,
service.
that's fine. So if I understand you correctly, you're outside of church, your primary connection, primary involvement with Austin was when he was between 10 and 12. Is that right?
Yes.
What position did he play then?
Offensive line and linebacker.
Okay, good. And what position did he play when he was in high school?
Still trying to play linebacker.
Okay, I got you. So obviously, fortunately or unfortunately, typically when the judge sits on the bench, she sees somebody in sort of one way,
Right.
as a defendant. You understand that? That's not really how you know Austin. So tell the judge a little bit about the Austin that you know that she may not have seen.
Yeah. As his mother stated, very compassionate kid, willing to learn,
Nobody
could
says
take
anything about
instruction
him
very
being
well,
smart.
team oriented. I never had a behavior issue out of him
Well-
being disrespectful as it relates to the football side. When it came to personal life, there are times that his mother did ask me to get involved, but it was more of staying consistent as it relates to his education side, as he had challenges as it relates to learning, and the frustration of wanting to be productive, but what comes easy for other people, he found difficult for himself. So.
Tell me exactly what you're
Maybe.
thinking about when you say that. What comes easy to others is difficult for him.
I believe we really came down to understand that Austin had a learning disability or could be tabbed with a learning disability. So needing to have that extra attention as it relates to understanding things is what he struggled with.
Okay, and when you say learning disability, you talking about dyslexia, ADHD? How does it? I'm not asking you for a diagnosis. I'm asking you sort of how it struck you in terms of his learning style and.
Without being offensive, slow, needing to be repeated over and over, so that he gathers. Having a hard time to really comprehend what somebody may consider basic instructions.
Okay, and something about this job and something about just the life that I've lived always leads me back to fatherhood. Have you gotten a story with Austin's dad, the role that he played or may not have played in his life?
Yeah, his father wasn't around. I can't recall ever seeing him at a game. And the issue of growing up and trying to gain identity, but not having the person that brought you into this world not being in your life was difficult.
Okay, and absent is a lot of different things. Absent is dead. Absent is in a different state with a different family. Absent
Different
is
state.
here, right around the corner, but don't want to have anything to do with you.
Right.
What's your understanding of the role that Austin's father may or may not have played in his life?
That he was in another state.
I got you. Thank you very much. The prosecutor, he may have some questions.
Questions from the state? No, Your Honor. All right, thank you, sir. You can step down and return to your seat. Any other witnesses for the defense?
No, Judge, thank you.
right, then let me hear any further mitigation argument or anything else from you before I turn to the state's presentation.
Oh, I'm sorry, Judge. No, Judge, ultimately,
Sometimes I spoil my remarks in the questions that I ask because I do believe that it's true that what courts typically see, what court reporters, judges, bailiffs typically see is they see folks, I'm gonna say being held accountable or being accused of something that they've done in the worst 2 or 3 or 5 minutes of their life. And what I try to do, which I'm gonna be honest with you, I've never been good at it because I've never been a poet and I spent a lot of time in school, but it was learning big words and handling big concepts. It really wasn't spending much time with your feelings. As I said in the closing remarks, I just didn't spend a lot of time with feelings. And all of this now is about what the court believes is a fair and just punishment for ultimately what happened. And at this stage, when the court is contemplating sentencing, feelings have to come into it because I agree with the prosecutor. There's something super offensive about being in your friend's mother's face, smiling and lying to her. But ultimately, he's not charged with that. If he was charged with lying, it's nothing I could say to dissuade the court from giving him whatever punishment the court would want to give, because I was raised by a father that taught me from very young, I'm gonna say 3rd grade, a liar will do anything. I didn't believe it. Still have trouble with that saying, a liar will do anything. You mean if I eat the last of the ice cream and I lie, I might kill somebody? A liar will do anything. That's what my father taught me. And there's a part of me that believes that, which is why I try to always be honest. And there's something super offensive about being in the mother's face and smiling and acting like you don't know what's going on when you know exactly what's going on. So I agree with the prosecutor on that. That there's no way ultimately around that. But what the court has to sentence my client on is the taking of the gun, not really to keep it, but obviously the jury found what they found. The taking of the car, and ultimately the concealing of the body. That's what the court ultimately has to sentence him on. And in that regard, Judge, the totality of evidence, the lack of criminal history, I would respectfully ask the court to sentence my client to 10 serve 2, giving him credit for whatever time that he spent. Irrespective of the sentence that the court might give Mr. Austin Ford, I would respectfully ask the court to sentence my client to first offender, which ultimately would allow him to walk out of the courtroom not a convicted felon, would allow him, once he paroles out or maxes out, to not have a felony conviction follow him for the rest of his life on the 3 charges ultimately that he was found guilty of. Thank you very much, Judge.
Thank you.
I wasn't that impressed by that.
Present the remainder of your case as you deem appropriate.
State's going to call Tory Lang to get his victim impact statement.
And here comes the family of the victim.
Good morning, Your Honor.
Would you like Mr. Lang at the podium or on the witness stand?
On the witness stand, please. All right, and for, I should have said this at the beginning, but I will say it now. Victim impact statements are to advise the court of how you feel about sentencing and what you believe to be appropriate and what you're asking me to do. I would ask that you not directly speak to Mr. Ford, as that would not be appropriate. All right, please have a seat.
Right hand. You swear or affirm the testimony you're about to give in this matter now pending before the court should be the truth, the whole truth, nothing but the truth. Nothing but the truth, so be that.
I do.
Say your name for the court reporter.
My name is Tory Lang.
Torreylang.
Mr. Lang, what information would you like the court to know about sentencing this man?
Really don't have too much to say, Your Honor, without being offensive or, speaking as if though I'm speaking out of vengeance or what have you. I'm a father that's still grieving, and I understand that these court proceedings have rules and regulations in place, and, it's not my job to tell anyone how to do their job. My job as a father was taken away from me, unfortunately. Sitting through these proceedings, I tried to remain humble, even through all, the direct and indirect insults and hearing things. I would ask the court to do what it feels is necessary to keep bad people off the streets. I understand that there's individuals who work, who has a job to free bad people, and I don't agree with a lot of stuff. I hear that. Sorry, Anna. Just hearing all of the stuff that's being said, all of a sudden, individuals are church-going, law-abiding citizens, and my daughter, she's going.
That's
I
the
can't
place
do nothing to
of
bring her back, but
the deceased.
she didn't deserve to die, and I don't wish this type of pain on no parent. There's an old African proverb that says, if there's no enemy within, the enemy outside could do us no harm. And it's an unfortunate situation where it was hard to determine who the enemy was. Again, I don't want to speak as if though I'm the voice of vengeance or somebody who just want bad things to happen to people who do bad things, but I would ask the court to just do what's right, because I understand that these proceedings and, the system has been allowed to let people do their job and manipulate the truth. And I would hate for this tragic in our lives to set a precedent for people to think that they could lie their way out of murdering individuals. I don't wish death on no other person, but I just hope that this situation doesn't give the notation to individuals that they could just make a mistake and get away with it, just conceal a lie, or however individuals may put it. But I don't want to take up too much of your time, Your Honor. I'm still dealing with, this grief. I was an active father. I wasn't an absent father. I was there every day, doing homework, helping with science projects. And to hear certain things as if though, my daughter was suicidal or she didn't deserve to be here because she was overweight and all this other nonsense. It's hurting, but, my family and I realized that this won't be an easy healing. And again, I'm going to try to maintain my humbleness as I've always did, with respect to other people and integrity to my fellow human being.
She had 2.5 times the prescribed top level of diet pill. Yeah.
So I understand that he's very upset with the defense counsel, but the defense counsel isn't lying. You can't just lie and make things up.
Yeah, and she wasn't prescribed this drug.
I mean,
Yeah.
We haven't seen any medical records where a doctor prescribed them, and if she was given, say a 90-day prescription and she went through them in 20 days, that's cause for concern. And for the love of all that is flaming hot Cheetos,
Yeah.
can we
And
dress for court?
she didn't in the second trial, but counts 6 to 8 is regarding the first trial. So I would assume that they have to go by the testimony from the first trial in this sentencing.
And I get that he's probably hypersensitive, and anything that even remotely touches on possibly even shading that she was upset, anything that doesn't basically say, this boy did this to my daughter, he's going to take wrong. But
Yeah.
he's
Daily quick bites. Were these pills capable of causing psychosis? Side effect was extreme mood swings, bad thoughts. So more or less, take too much of that drug, unprescribed, unneeded, maybe with other drugs. And well, in my opinion, it was more probable that she either did it herself or asked him to do it for her. Now, the jury couldn't convict, so this is only counts 6 to 8. So I feel for him, and I understand why he says this, but this is only counts 6 to 8.
I don't want to dwell too much, Your Honor, because I don't want to, again, seem like I'm being in a place of vengeance, but I would ask the court do think it's right and keep bad people off the streets, Your Honor. That's all I have to say.
Thank you, sir. Call your next witness.
Tanya Lang.
Morning. Watch
okay,
your step.
Granny understood the assignment. Granny always understands the assignment. Okay, well, never mind. She's wearing the same damn shirt.
You swear or affirm the testimony you're about to give in this matter now pending before the court shall be the truth, the whole truth, nothing but the truth, so help you God.
I do.
And spell your name for the court reporter, please.
Tanya, Tanya. Last name Lang, Lang.
And Ms. Lang, what do you want the court to know before it sentences this defendant for the offenses for which he was convicted?
Okay, first, just let me say, Your Honor, I really misunderstood what this day was about. I really was under the impression that you were allowing us a platform to talk about Tori and what she was about, or you know what I'm saying? That's what I was under the impression. But learning now that you need to know what we feel about the sentencing.
I'm not preventing you from telling me what you want to know.
That's what I'm trying to find out. Am I limited to certain things or whatever? Or can I just talk about Tori?
I can't really tell you what to say, ma'am.
Okay.
So just tell me what you want me to know. And if anybody takes exception to that, then they will let me know. But you just proceed.
And Ms. Lang, obviously, how you feel about sentencing as it relates to Tori, if that information relates to the sentencing, then I think that's what the court is looking for.
Okay. Before I give my view about the sentencing and what I think should be done as far as sentencing, there was a statement made, and I'm sorry, I just feel compelled to address it. A statement was made in this court, and it was an insult to the family. And my son, he's too humble to say anything. Tori is not here, but I am here. And because our mother is gone, I am the matriarch, and I'm going to speak for our family. The statement that, they love her now. Now that she's gone, they love her. I think that was one of the most heartless, insensitive things for a person to say, especially in the presence of her parents that are suffering the grief and the loss of the only child that they had. However, in hindsight, I just feel like the only way a person could
Defense attorney said it in closing, because she was passed around family.
Yeah, I mean, I can see how that would bother someone, but I can also see how the defense, two things can be true at the same time.
Yeah, they can still
Teenage
love her.
girl can be being a damned pill and a half, because I may have 3 of them. And you can, so yes, you can love your child while they are being a pill, and you can love them while they're gone. So now they are choosing. Look, it would be immensely hurtful to hear that. But two things can be true, and I don't think he meant it in the hurtful way, but I could see how that would be immensely hurtful to hear. But I can see where he meant it and maybe didn't mean to give offense, and how it would be super.
fix their mouth to say something like that is if they never experienced that kind of love. So they would not understand that. Before Tori drew her first breath, she was loved so much by so many because we anticipated her arrival. Everything Tori ever did in her life, we celebrated, and not on no small level. Tori was supported, and she was celebrated her entire life. So, I mean, that was just weird to hear that being said. Now, as far as the sentencing for Austin, I just don't see how the court could sentence him in accordance with his involvement in this case. Because the truth of the matter is, for the rest of his life, there'll be a dark cloud over his head. See, Tori's not coming home with us. Tori's not coming home with us. Austin not going home to his family either, at least not now. But at least they can see him. And his mother knows that at some point he will be coming home. We don't have that blessing. We don't have that opportunity to see our baby again until Jesus come back. And that's only if we live right. And that's in the Bible, and that's God's word. And that's what I'm doing. I'm trying to live right so that I can see her again. So as far as sentencing him, if he walk out that door right now, he will never have peace. Never. So whatever the courts want to do with him, I'm with my son on that. I'm with my son on that. But I just hope that in considering or making the decision, whoever is making the decision about his sentencing, put themselves in our shoes. If it were your daughter, your only child, we have people getting up here,
convicted of.
One witness testimony was like 90% of the testimony was about her accolades and, the thousands of bodies that she, worked on and what have you. But she wasn't a crime scene investigator. She was an ME. And with all these accolades and all these hours, she still couldn't come up with a determination of how Tori died. I really was under the assumption that the cause of death was a gunshot to the head. Now, far as I'm concerned, that was all she had to say. Anything after that, I think, should be left up to CSI members. They're the ones that specialize in that. And then at the 11th hour to come in and say, oh, I don't know, I think I'm kind of leaning towards suicide. Get out of here. Miss me with that. I think that Even the time that Austin has been behind bars, he knows that he's going to probably live in fear for the rest of his life because he knows Tory's family. Not that we would ever do anything.
Oh shit! Do not tell him to
If,
keep
if
his
you
head on
have
a
a
swivel.
certain guilt, you understand? You will always be looking, Tory's old boyfriend, anybody. So the only thing I do right now is just pray and ask God to give us the strength to get through this grief. It's been 2 years. And even now, the pain is so immense. Sometimes I'm just numb. Tori wasn't my baby. I didn't give her birth, but she was my baby. And everybody knew that. Tori was so loved. And if you never had love like that, unconditional love like that before, you probably just don't even know it exists. And this is why the family is really upset about that statement. That's why I had to address it. So again, whatever the state feel or deem, should be done with him, you just have to accept it at that. Because really, in our eyes and in our hearts, there's no punishment that the state could give him that would justify what has happened. And that's all I have to say.
Thank you. Watch your step coming down for me.
Thank you.
Take your time. I thought I heard someone's cell phone. So this is the last time I'm going to say it. If you are not an officer of the court, power your phone all the way off. Not on silent, not on airplane mode, off. Please call your next witness.
Yeah. These witness statements are, everybody still believes he did it. And they are in their right to believe it, but he is not convicted of it. Now, this might sound heartless of me, but this is on the prosecution. He knows exactly what he's doing, and he is being an asshole for it.
Well, and so this is also, I'm sorry, but this is also I can't really speak on this again with current political things, but there are certain communities where mental health issues are not particularly well received, where going to get mental health, help is not well received. So if you had maybe a girl who was loved, who was absolutely loved, let's say, and she was showing, she was acting out and showing that she had issues, going to a therapist, going to a counselor, getting, anxiety medication would be frowned upon. So it's easier for them to think that this young man did it than to think. So it's sad all around. And this prosecutor is a dick. And Granny just called out a daggone hit in the courtroom. Like, keep your head on a swivel, dude. Good Lord.
No, this is it. There will be no trial of murder or anything. This is counts 6, 7, 8. Alternatively, she said that he will always be scared. Not that they will do anything, but he might think. But
well, I did recommend he move out of the state and keep his head on a swivel. But I mean,
yeah. Only weak-minded people need help, and and then, have you ever heard any man get the advice? I get the advice all the time. You need mental health, but that's from Twitter trolls, so that doesn't count. But men rarely gets that advice. Just suck it up and move on. And
so it really seems like a sad thing all around, and the fact that the prosecutor didn't sit down and say and tell the family, the fact that the prosecutor didn't sit down and say, "This is what your statements are going to be about. This is what the judge is going to expect. I know this is going to be a hard day, but this is kind of how, you need to model this, or this is what these things are." So the fact that he just sent them up there with like nothing, that's a dick move.
Yeah, and remember, the father never testified in court. The prosecution never called him to speak about family, how they work together, because the victim was raised by a single mother. So, yeah. But let's continue.
Raise your right hand, please. You swear or affirm the testimony you're about to give in this matter now pending before the court shall be the truth, the whole truth, nothing but the truth, so help you God.
I do.
Please say and spell your name for the court reporter.
My name is Tamara Lang, Tamara-Lang as in George.
And what do you want to know, what do you want to let the court know about sentencing in this matter?
She shows a lot more feelings than she did in when she testified. Before she speaks, I will tell my honest opinion about the mother of the victim. She knew her daughter had mental health issues, and she did jack shit about it. But she needs someone to blame, because otherwise, if somebody else didn't do it, then she either was a contributing factor or ignored everything about her daughter's issues.
Yeah, pretty much.
So, her actions on the stand while in trial,
she did not.
Yeah.
Well, guys, I have to run. Had court started on time, I would have been ready to go, but I get to go to physical therapy. Super awesome. But I will be listening and probably irritated. Hopefully he does not get 30 years. I will probably do a video about this tonight, but have a wonderful day, and I will probably have some more videos coming out tonight.
Okay, thank you for showing up. And
yeah, sorry about that. I just looked at the time and I was like, oh, holy crap, I have to leave.
Okay, thank you. And well, everybody, Jesus Christ, get over to her after this, and yeah, subscribe to her and like everything she's ever done, while I'm going to be an asshole towards the mother.
Sounds good.
Okay. Bye. Mad says here, in all fairness, do we really know what the mother did or did not do to help her daughter? Yes, we do. In the first trial, she said that they went to the hospital a few years before this happened. She stayed overnight or longer in the hospital, and that she had put some pills in her system. In the second trial, she had no memory whatsoever of this. Her memories changed completely between first and second trial. So yes, I do believe we know that mother either was ignorant as fuck about her daughter's issues, or she knew and did jack shit. So yes, I'm going to be an asshole towards the mother because I don't believe her. That's my honest opinion, and now you can call me out on it if you want.
I have something that I want to read, but before I read it, I am Tamara Torrey's, what we call Kiwi, aunt and godmother,
Oh,
and I've helped raise her in her entire life.
that's the aunt, not the mother. Sorry. I will say the same when the mother comes. We'll say it again when the mother comes on. This is the aunt, who, by the way, this is one of the homes that the victim was jumped around to. She was either at the mother's home, at the parental grandmother's home, or at aunt's home. Bounced around like a freaking ping pong ball. If she did, she would have testified to it, or the defense would have brought it up. Never happened. Mother isn't there today. I don't care.
A month from today would be September 16th. We would have been celebrating her 21st birthday. And like Mama said, we don't do anything that is not colossal when it comes to our only child. But instead of planning this year, we've had to deal with the past over 2 years, the hurt, pain, and tragedy of what has taken place and the loss of our only baby. As far as the sentencing go, I'm going to speak on that first. The only thing that I continuously think about is looking out the window to make sure my baby car was outside and she'd come home. The constant text with her being the only one with the car and having to bring friends and pick them up and rip and run and having conversations of not really understanding what friends are. My friends I've had for 30 years and my friends don't use me. And I've constantly had to think about those conversations when I fix morning coffee and talk to her. When we were looking for her and all of this took place, I keep seeing, I can't say his name, the defendant, when I pulled up from the funeral home to make arrangements, his mama standing outside of my home and him going in my home to bring Mama Lane flowers. And I knew something. At the funeral, the only picture in my head was him taking pictures in front of her horse and carriage ride like it was a fashion show red carpet. That image has never left my head. The phone call and text message of identifying her, of which I had to do, and send pictures that has never left my head. He needs to be sentenced to the max. Who as a friend could leave a friend laying killed in a park with a gunshot to their head, and for months lying to us, and point the blame at other people? No friend would ever do anything like that. Your friends cover you. Your friends pray with you. Your friends hold you accountable if you are a friend. So I am asking that the court have mercy on my family and judge the maximum sentence. Coming into this court time after time, motion, every little thing we've come for, and for him to have a smirk on his face. To watch that. And his mother, they're looking at us like we did wrong, and we are not the ones here who has transgressed and hurt and left somebody dead. This is the hardest thing in life that we've ever had to deal with. And I'm asking you, Judge, to see and put yourself in our shoes. We don't have our only child. All we have is memories. And with that being said, I will read what I provided. Tory Lane, Kiwi's dash. The dash on a person's obituary between the date of birth to the date they leave Earth represents a person's life journey on Earth. And only those who love them know what that little line was worth. On September 16, 2002, a star was born, Tory Mache Lang, affectionately known to her family as Kiwi.
A kiwi is fuzzy on the outside, but soft and sweet on the inside. That was our baby, our kiwi. Kiwi was born big, B-I-G, blessed in God. From a toddler at the tender age of 2, Kiwi had so much compassion and care for others. We would be amazed at how she would say the sweetest, most comforting words. At 2, we decided to enroll her in a school that focused on being diverse and bilingual. Imagine, to my surprise, picking her up one day and hearing her sing numbers in Spanish. Kiwi was big, B-I-G, bright, insightful, and gentle. Kiwi grew up an only child, and although she had many cousins, she thought everyone was her friend. No matter how much she would share her toys they would break or her snacks they would take, she was always willing to see the best in them, making excuses for their actions and behavior. Kiwi was big, B-I-G, believed in seeing good. Kiwi has taken cheerleading, acting, modeling, traveled to other countries, cruises, and explored many water and theme parks. She was in the choir, although she couldn't sing. Kiwi was always on the honor roll, and teachers adored her. Her love for math was amazing, and she would do math problems that I would pass over and pray they would get worked out. So many of her schoolmates have shared with us how she helped, tutored, and gave them grace while grading their assignments they struggled in. Kiwi was big, B-I-G, brilliant, inspiring, and gracious. Amazed by skyscrapers and uniquely designed buildings, Kiwi had dreams of being an architectural engineer and was enrolled in engineering school, also taking dual enrollment, which is taking college courses while still in high school. She was
I understand why they want to talk about this and why the defense doesn't want to oppose any of it, because it simply looks bad. But at the same time, everybody is speaking towards him committing the crime. Here's the thing, he is not convicted of it. So would I have been the asshole to interrupt? Probably. Because this has nothing to do with the crimes he is actually convicted of. And for me, the evidence in this case spoke way more towards her self-ending herself. So whatever her achievements was, however brilliant she might have been, he's not convicted of ending her.
very creative and worked on several inventions with her daddy, who always told her, the baby is going to do great things. Kiwi had a charismatic aura that drew people to her that came from her mama, her grandmother. Her beautiful smile, personality, and grace, of course, came from me. And her brains and beauty came from her mama and daddy. But not just beauty on the outside, but beneath the surface. She was taught that God searches our hearts. And yes, she journaled to God. Well, at least we know she knew him. Kiwi was big, B-I-G, believer, incomparable, and gentle. When hearing the question in court, asked to young adults, where do you think you will be? At age 30, it was very heartbreaking. All I could think about was where our baby was. If I knew my key, she would be in the prime of her architectural engineering career, owning several businesses, maybe even married, but never too busy to spend time with her family.
As far as I know, she barely could hold a job down, which was testified to in court. Which speaks, if she was that good in school, and still, that speaks towards her mental health issues.
And most of all, her mama, her true best friend. But now, all we have left are memories. No wedding, no grandbaby, no engineering career, no creative inventions, and the family gatherings and trips will never be the same. With all that I said, I know that Kiwi's life left a lasting impression on many. It wasn't the things we gave to her, but what we instilled in her. Kiwi was big, a bright, incredible gift. She is a loved child by many, a beacon light, the joy of our life, our precious baby, our heart, our Tori, our Kiwi. Thank you, Judge.
Teresa Lane. Raise your right hand, please. You swear or affirm the testimony you're about to give in this matter now pending before the court should be the truth?
Oh, there she is.
Yes.
Okay, there she is. Well, I don't want to repeat what I said earlier, but you already know my opinions about this woman. I mistook the aunt for the mother, and I gave a speech about it. And you can go back and watch that because it applies to her.
Please say and state your spell your name for the court.
Teresa Lane. Teresa-Leng.
Okay, so what do you want the court to know before it sentences?
Right now, y'all, I'm so hurt, angry. I feel weak, tired. I feel like for the rest of my life, I'm gonna have to fight for my baby. It's like it's never gonna end. I have to see that her legacy lives on through me, her father, her family. I'm just hurt and just disappointed by everything. It really shows me that life is not fair at all. I'm lost for words. I'm just hurt. Every day I get up, get dressed, comb my hair. You can see the hurt in my eyes, my husband's eyes, my family eyes. When I look at him, it looks like he's sleeping good every night. Every single night. You know why? Because he's evil. Heartless. Only people like that can sleep
I
at night.
would strongly object to this. She's not supposed to talk directly to him.
As far as the sentencing, Your Honor, I know it would never bring Tori back, but at least you can get a peace of mind, some type of peace of mind. I just think if you would have just said something cold, I called him and told me my baby was out there in the darkness, animals, bugs, laying there like a piece of trash all night long. I want to see him on the Ring camera, just so going by his day like nothing ever happened. Like,
You change your testimony between trials, and you will get away with it. No, I have construction done downstairs. That's the buzzing sound you're hearing in the background. Sorry.
he didn't see her. No, he left her there. Her just left her there. Just left her there, lifeless. When I spoke with him that night, he heard the fear in my heart, in my voice. You need care. Yeah, I don't know what to say. I just feel. And then whatever we say, however we feel, you have to do what you have to do. That's all I have to say. I can't.
No other witnesses, Your Honor, just some final remarks. I'll wait till Ms. Lang is seated. Your Honor, I understand that this defendant is eligible for first offender, and none of these offenses are prohibited by law for this defendant to be sentenced under the First Offender Act for them. It's the court's determination to balance whether or not society has a greater interest in knowing that this defendant has been convicted or what he has been convicted of versus whatever benefit there is to him. And I have no choice but to leave that in the discretion of the court. But I do take exception with the suggestion that the state makes this recommendation out of a sense of revenge, or is asking the court to sentence him for the murder it didn't convict him of.
Sorry. This prosecution takes offense when the prosecutor was the one who pushed for this trial, even though he knew what his medical examiner, her conclusion, and what she leaned towards. He chose to push the family through the court. He knew that the mother changed her testimony. We don't know how or why if she was advised to, or if she did it on her own. So the prosecution taking offense, this is your own goddamn fault. None of this would have happened if you just said, okay, here's the 3 charges we can get into. Our medical examiner says this. Let's investigate properly about the mental health issues.
I take a strong exception to that, because as the court can see, this is the single most heinous, callous, cold, and calculated way to commit the 3 offenses that the defendant was convicted of. And when it is the single most callous, cold, calculated way, it is appropriate, even on the first offense, to sentence the defendant to the maximum for that offense. The law prescribes a certain thing as the maximum and allows the court to run offenses consecutively. The court's not being asked to do anything outside of the law. Disingenuous simply to suggest because it suits your needs that it's simply out of revenge. It's not. Your Honor, the state believes its recommendation is appropriate, especially given the impact these offenses had on the Lang family, the heartless way in which it was committed, and the purpose for which it was committed, which was to conceal ultimately Tory Lang's death for as long as possible. For that reason, Your Honor, the state's respectfully asking the court to follow its recommendation.
Thank you. Anything final before I prepare to move forward with sentencing?
No, thank you, Judge.
All right, give me a moment to collect my thoughts.
I would assume she will go to somewhere in between, because it is troubling that he lied, that he went to the funeral, that he kept silent for so long. It is.
All right, having presided over both jury trials in this case, As a judge, I do not know what happened in Yellow River Park. I was not there. The attorneys were not there. The families were not there. And oftentimes in jury trials, you have the state's version of events, the defendant's version of events, and oftentimes the absolute and unequivocal truth lies somewhere in between those two versions. I acknowledge that 2 mistrials after 2 jury trials does not provide any closure for the Lang family. But honestly, I don't know what could possibly provide closure to the family under any circumstance. And I recognize that. I can't sentence Mr. Ford for the offenses for which he was not convicted by 2 juries. But I am authorized to sentence him for the 3 offenses for which he was convicted. With that being said, I impose sentence as follows. I'm going to start with count 8, concealing the death of another. For that offense, I impose a sentence of 10 years to serve in confinement.
Oh,
He'll be entitled to
shit.
credit for time previously served on these charges as he is lawfully entitled to and as determined by the custodian. On count 7, theft by taking of the motor vehicle, I impose a sentence of 10 years probation consecutive to count 8. On count 6, theft by taking of the firearm, I impose a sentence of 10 years probation concurrent, which makes the aggregate sentence on all 3 counts a total of 20 years, the first 10 years to serve in confinement.
Jesus
I impose the
Christ.
following conditions: a $1,500 fine plus any court costs and surcharges, the monthly probation reporting fee, the indigent defense application fee for the services of court-appointed counsel. I order that while he is on probation, he is not permitted to consume any alcohol or drugs unless they are lawfully prescribed to him. He will be subject to random screens and must waive specimen admissibility in any court proceeding for any positive screen results. I order that he undergo an alcohol and drug evaluation and that he complete any recommended treatment. While on probation, he is not to have any contact of any kind, directly or indirectly, with any member of the victim's family, their residence, their place of employment, or any school location. The defense has asked that I treat Mr. Ford as a first offender. It is undisputed from both sides that he has no prior criminal history and he appears otherwise eligible for that treatment. However, taking into account everything that I'm lawfully entitled to consider, I decline to sentence him as a first offender. I also order that the state present to me today a null pros order on the preceding indictment in case 22B 03732-3. I also note for the record that the indictment in which issue was joined for the second trial was provided to Ms. Banks-Brown at the conclusion of the hearing, and that indictment will need to be filed with this court's sentencing order. I believe I also need to address, even though I had entered an order on the mistrial for counts 1 through 5, this sentencing order will reflect a mistrial for counts 1, 2, 3, 4, and 5 on the sentencing order. I'm sorry, thank you. Counts 1, 2, 4, and 5. Count 3, voluntary manslaughter, was a directed verdict, and the sentence sheet should reflect that. Let me advise Mr. Ford of some appellate rights, and then I'll turn to each side to determine if they take issue or need any clarification on the court's sentence. Mr. Ford, if you feel that your rights were violated, you may challenge your conviction in one of 2 ways. First, you have a right to directly appeal from your plea by filing a notice of appeal within 30 days of the date that your sentence is filed. Second, you can challenge this proceeding through a habeas corpus petition. That must be filed within 4 years for felony offenses, and all of your convictions are in fact felonies. And that 4 years runs from the date that your sentence is filed. Mr. Ford, do you understand these rights? To further clarify on your right to appeal, you do have a right to seek post-judgment relief from your conviction of the crimes by either making a motion for new trial in this court and or by filing an appeal to a higher appellate court. If you want to file a motion for new trial or an appeal, then you will need to file the appeal. You will need to file the motion or a notice of appeal with the clerk of Superior Court of this county within 30 days. You can discuss that more fully with your attorney, Mr. Lewis. If a motion for new trial is in fact filed, and after a hearing, I deny that motion for new trial, then you will have 30 days from the filing of the order denying your new trial in which to file with the clerk of the court your notice to appeal to a higher court. You have the right to have an attorney represent you on your motion for new trial and the first level of direct appellate review. If for any reason you cannot afford to hire an attorney, the court will provide you an attorney and one copy of the transcript of your trial at no cost. Mr. Lawrence Lewis, I'll ask that you file the initial motion for new trial within 30 days. And if you are requesting to come off of the case for appellate purposes, if you will indicate that, and I will appoint Mr. Ford different appellate counsel if he wishes to appeal. All right, let me turn now first to the
Okay,
state.
they will appeal the
Any
sentencing.
questions or clarification needed on the court sentence? No, Your Honor. Mr. Lawrence Lewis?
I don't know the credit for time served date. I don't know if the prosecutor is making a suggestion. I do know that March 29, 2022 was the interview with the lead detective, and I do know at some point in time my client made his way to the Gwinnett County Jail. I suspect that at some time between the time that the detective spoke to him and the time he arrived at 2900 University Parkway, warrants were filed against them and holds were placed, but I don't know that date. So I don't know if the court is going to try to figure out, or if we should figure out what that credit for time served date is now, or if you just leave it to the calculation of the custodian, and then if I disagree with that, I'll file a motion to amend the credit for time served date. I don't know how you want to handle that. I just don't know what his credit for time served date is, Judge. And obviously, I would ask that he receive credit for time that he served. The date back to March 29th would give him 16 months. I think at the date when he arrived would probably be closer to 14. So I'm not quite sure what date the warrants dropped and the hold was placed on him when he was in Clayton County.
All right, and I typically stay out of that dispute. It is within the purview of the custodian to determine what credit he is lawfully entitled to receive. For that very reason, I do not put a specific date. I leave that up to the custodian. That is within their purview to determine the appropriate credit. Any other issues with the sentence as announced from the defense?
No, thank you, Judge.
All right, Mr. Ford, do you understand your sentence? All right, I also instruct the state to maintain possession of the evidence, to file an evidence and retention log with the court at the earliest convenience. All right, then that is going to conclude the sentencing hearing. Mr. Ford is remanded to the custody of the sheriff.
Okay, so 10 years plus 10 years.
All right, we will now switch gears to a related quasi-criminal matter.
10 years plus 10 years probation. It's up to the custodian to calculate time served. It is, I believe the defense said somewhere between 14 and 16 months, but that is up to the custodian to decide that. And if they have to serve 75% of the time, that is 7.5 years minus 14 months. So just over 6 years. That's a lot. Yeah, but I do believe that the defense said that they would appeal the sentence. So let's see. The big thing there is it was counted as a felony, and that will follow him the rest of his life. But if they get rid of the felony, then he might actually have a future.
Under the same docket number 23B00981-3, in Ray Sheila Holly, on the matter of contempt. Neither side is a party to this contempt action. This is the court's motion, and the court will proceed with witnesses as it deems fit. Let me have Ms. Holly at the defense table, and I'll need if you could remove Lawrence Lewis's documents, please. And Mr. Smith, if you could join your clients. right, the state is not a party. You're free to remain, but you are not a party to the action. So if anybody wishes to leave the courtroom before I start this hearing, please do so now. All right, Mr. Smith, good morning. How are you? All right, are you in receipt of the court's prior orders regarding the contempt and the notice of hearing for today? Okay, well, that's the copy that was filed. So I just turn to you if you want to make any opening remarks. If not, it's the court's hearing and I will call my first witness, which would be Deputy Odom. But do you want to make any opening remarks? All right, then I will call Deputy Odom to the witness stand, please. If you will be comfortably seated in the chair and raise your right hand. All right, do you
That will be a separate hearing. It's called, well, it's up to the court to decide. Well, he doesn't have legal fees, first of all, but he might be, they might ask him for restitution towards the victim's direct family. So that will be a completely separate hearing, but I will probably not cover that. It's a very small amount since I'm not entirely sure they can recover anything from him since he was only convicted of theft and concealing the death of another. Maybe. I don't know. But we'll see.
swear or affirm that the testimony you'll provide the court in the pending matter will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, lower your hand and please state and spell your name.
My name is Rebecca Odom, Rebecc.
The mother managed to get herself, mother of the defendant managed to get herself into trouble by taking pictures in the courtroom. One picture was of jurors. So that's a bad idea. So this is the contempt hearing for that.
Odom.
All right, and how are you employed?
I'm a deputy sheriff with Gwinnett County Sheriff's Department.
All right, Deputy Odom, were you assigned to this courtroom, courtroom 3F, for the criminal jury trial in the State versus Austin 4 that commenced on Monday, August 7th, 2023?
Yes.
And were you assigned to this courtroom each day that that jury trial took place?
Yes.
Were you present in the courtroom for the trial proceedings, accepting any lunch, recess, and breaks?
Yes.
Did you hear the court at any occasion provide instructions to courtroom observers regarding cell phones?
Yes.
What do you recall that instruction to be?
The instruction I recall were that everyone who is not an officer of the court to have their phones powered.
I just had to. He's not hiding a corpse. It was hiding the fact that she was dead. Concealing the death, not hiding a corpse.
All the way off.
All right, and do you recall if I made that instruction on more than one occasion?
Yes, I do.
Do you recall if that instruction was in fact made on more than one occasion for each day for which the trial proceeded?
Yes.
Are you familiar with Sheila Holly?
Since the duration of this trial, yes.
Okay. And was there something regarding Ms. Holly that caught your attention during the trial proceeding?
Yes. On Wednesday, August the 9th, it was at the end of the day, about 4:50 to 5 o'clock. We were about to adjourn, and the jurors were leaving out. And you were, after the jurors left out, you asked for the deputy to take Mr. Austin back in custody. So as Deputy Hilbert was removing Mr. Ford, then he saw that Miss Sheila Holly had her cell phone, and it looked like it was in video mode. So he got her phone and he handed it to me because he had custody of the inmate. And when I looked at the phone, that's when I saw that it was looked like video mode. And there was a picture in the small corner of the courtroom. That's when I advised the court.
All right, and that was a cell phone that was retrieved from Ms. Holly in the courtroom?
Yes, ma'am.
All right, and Do you have that cell phone with you today?
Yes, ma'am.
All right, Mr. Smith, you want to look at what I'm going to mark as Court's Exhibit 1, please?
Yeah. And if you so choose, I would really appreciate if you became a member. It's $3 a month, and you get access to members-only content and to the Discord.
To what I'm going to mark as Court's
Thank you.
Exhibit 1? No objection, Your Honor. All right. Let me have the court, we'll hand that to the court reporter.
And like and subscribe and all that, but you already know all that.
Right, Deputy Odom, and if you need to open the bag, that's fine. Can you look at the contents of what has been marked as Court's Exhibit 1 and tell me if you recognize it?
Yes, I do.
What is contained within Court's Exhibit 1?
This is a cell phone belonging to Miss Sheila Holly.
Right, and is that the cell phone that you seized from Miss Holly in court?
Yes, ma'am.
At this time, I will admit Court's Exhibit 1 into evidence for the record. Any objection, Mr. Smith? All right. I'm also, Mr. Smith, I'll show you what I intend to mark as Court's Exhibit 2. If you'll review that, please.
This hearing took a lot longer time than I anticipated. But hey, oh, we're over 2 hours. I can curtsy.
All right, Deputy Odom, if you'll look at Court's Exhibit 2 and tell me if you recognize it.
Yes, I do.
Does it appear to be in the same or substantially the same condition as when you first saw it?
Yes.
And what is Court's Exhibit 2?
Court's Exhibit 2 is what appears to be a photograph from the gallery of members of the jury.
Is that the photograph that you observed on the cell phone that's contained in Court's Exhibit 1?
Yes.
At this time, I would admit Court's Exhibit 2 for the record. Any objection, Mr. Smith? All right, it will be made part of the record. Can you tell generally what is depicted in Court's Exhibit 2?
What's depicted in Court's Exhibit 2 is members of the jury as they're sitting during trial, and there's Mr. Norris Lewis and what appears to be the Mrs. Banks Brown sitting at the prosecutor's table.
All right, and the jurors appear to be seated where in the photograph?
The jurors are seated in the jury box.
All right, and that appears to be, does that appear to be a picture that was taken during trial proceedings?
Yes.
All right, I have no further questions at this time. Mr. Smith, do you have any questions for Deputy Odom?
There's no indication that it was sent to anybody, to my knowledge.
All right, you may step down. Thank you. All right, Mr. Smith, I obviously don't want to get into any privileged communications between you and your client. I would rest on the testimony of Deputy Odom, so I don't know if your client intends to be placed under oath and take the witness stand to defend the allegations of contempt. If you could stand for me and use that podium mic, please.
Your Honor, we would concede on a per se violation of the order, but wanted to proceed on sentencing or adjudication.
All right, do you want to call your client to the witness stand and place her under oath for any mitigation?
Yes, Your Honor.
All right, she may do so.
We call Ms. Sheila Holly to stand. She's still considered under oath?
No, you'll need to place her under oath.
Raise your right hand. Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes.
And you'll need to speak loudly for me, please.
Yes.
And state your name for the record.
Sheila Holly.
And what is your relationship to the defendant in this case?
I'm his mother.
And how often have you come to his trials?
I've been here every day for his trials.
So did you understand that per the judge's order, you weren't allowed to have your phone powered on during proceedings?
Yes.
So on this occasion at issue, why did you have your phone on and why was a picture taken?
Well, Initially, my anxiety was so bad right before the court proceedings started that I went outside the court to power my phone off because I'm not a real good iPhone user. I don't normally use iPhone that much. While I was out there, the second chair attorney, Ms. Fallon, had came out there to let me know that the proceedings were about to start. I was explaining to her my anxiety was so bad that I just didn't know how to turn off my phone. So she went to my phone and she went into airplane mode. And she went to settings and then she went to airplane mode. And I said to her, I was like, I thought the phone had to be totally off. And she said, well, you're the mother. You have like a little extra privileges. I forgot the word she actually said, that you have privileges. And that's why I was like, well, normally my phone is off. She was like, you have provisions actually. So then I came into court. Then I came back into court after she put on airplane mode for me.
But did you see anything in the courtroom that I guess inspired you to take a picture?
I did. It was throughout the trial, several of the jurors were asleep. Right before I actually took the picture, it was one particular juror that the juror next to her continued to nudge her to wake her up. And she would wake up and then she would go lean to the side and go right back to sleep. So my anxiety was super bad. My son is on trial, where they're trying to take the rest of his life for him. My anxiety was through the roof. I snapped the picture. Immediately after I snapped the picture, I was like, oh my goodness, this is so wrong. I'm not supposed to use a phone, you know. And I was like, okay, I'm going to delete it, immediately delete it. And that was it. I just left it in my phone. I left it in my phone. When I was going to leave out the court, I was going to immediately delete it because I realized, oh my gosh, you're not supposed to take a picture, and especially of, any jurors or whatever. It's just that throughout the trial, several of the jurors were asleep.
So do you have any ill will or harbor any bad feelings regarding the jury or any of the proceedings?
None at all. And I felt totally bad that, I even disrupted the court. Like, that was not my intentions at all, at all. My anxiety was through the roof. Like, my anxiety was really bad.
No further questions, Your Honor.
All right, I do have some questions for your client. Ms. Holly,
Yes.
you attended both the first jury trial in April as well as the second jury trial in August, correct?
Yes.
And do you acknowledge hearing me repeatedly say multiple times a day throughout the proceedings the court's position regarding cell phones?
Yes, Your Honor.
And did you in fact hear me say that your phone needed to be completely powered off, not just on silent while you were in court?
I heard you say that. Yes, Your Honor.
So despite that, you still came into the courtroom with your phone powered on. Is that correct?
In airplane mode, yes, Your Honor.
And despite whatever anxiety you may have been feeling, you knew that it was wrong to take a picture of the jurors in court during trial.
Yes, Your Honor.
And at no time did I give you permission to power your phone on in court. Is that correct?
You're correct, Your Honor.
And at no time did I give you permission to either take a picture or have your phone in record mode during the proceedings.
My phone was never in record mode.
Okay, but at any time did I give you permission to do that?
No, Your Honor, you didn't.
All right, I have no further questions. Any redirect to Mr. Smith? All right, you can step down, ma'am.
So here's the thing.
All right, Mr. Smith,
I really want to. I know they can't show the photo,
any
but
mitigation
if
evidence,
there
I intend
actually
to
is someone
give
sleeping,
her a
that's
chance
a
to make
kind
her
of
way
a
back to
big
the table.
deal. But the defense didn't brought it up, and the prosecution didn't bring it up.
Any
So
mitigation regarding consequences, let me make a finding first and then have you can stay there. It's going to be a short finding.
Okay.
And then have you respond regarding any mitigation. Upon a consideration of the evidence and all matters of record, I do find beyond a reasonable doubt that Sheila Holly is guilty of indirect criminal contempt of court. I make this finding that she intentionally disregarded a command of the court by having her cell phone powered on without prior permission of the court and by improperly taking a picture of jurors seated in the jury box in the courtroom during court proceedings. I further find that her actions presented a danger to the orderly administration of justice in the trial proceedings. So having her being found guilty, I'll turn to you, Mr. Smith, for any mitigation. Obviously, having made this finding, It is within the court's discretion to impose a fine of $1,000 and/or 20 days in confinement. I'll hear from you before I impose sentence.
Thank you, Judge. In any case like this, there are multiple victims. Obviously, there's the family of the victim, who deserve all the sympathy and grace and love that the Lord can give us. There's also the family of the accused, because I believe no parent intends to raise their child to end up in a proceeding like this. And having gone through 2 trials and having the stress and the pain of her son fighting for her life, it was an emotional and impulsive act for her to take the picture, because in a proceeding that's this important, it has to be emotionally jarring to see the jury be unengaged, allegedly. But in her mind, the jury was unengaged and her son was fighting for her life. Now, she had no plans to intimidate the jury. There was no indication that she transmitted it to anyone else or made any improper communications with anybody involved in the case. This is just a emotional, impulsive mistake. And we ask that the court take that in consideration when imposing its sentence. She just had to witness her son be gone for at least 10 years, maybe up to 20. And before this sentencing, it could have been life. So I would ask the court not to compound that by sentencing her to confinement and to have to process what she has to process now, just 5 minutes ago, in Gwinnett County Jail.
All right, thank you. Does Ms. Holly want to be heard before I impose sentence? She'll need to come to the podium if she wants to speak. I'll hear from you, Ms. Holly.
Your Honor, I just want to say that I'm extremely sorry for what I did. I have not stopped thinking about it. I was even remorseful even after I did it. I realized how people would feel about it, and even think about it and think that I would attempt to do anything. And I would never. I actually would never do anything. I was super emotional at the time, just watching some of the jurors be engaged and sleeping several times throughout the trial. Too, it really put my anxiety through. It really put my anxiety through the roof. Um, the other thing that I did want to say is I had also been really remorseful even towards the family as well. Like I've had people say to me that, things about the family. And I myself was thinking of how many times I hugged the mother and even what she was going through. Even now during court, I was still telling some of my friends about how I just wanted to hug her and rub her back as I did so many times in the past, even though they feel so terrible about me. I'm just a lighthearted person like that. I feel for the mother. I knew Tori. Tori was in my house numerous times. Like I totally felt for the mother. I had no ill intentions at all towards the jury whatsoever. And my anxiety was just through the roof. That was it.
You can be seated at the table with your attorney. Give me a moment to formulate the sentence in this matter. I'm going to ask that the court reporter file court's exhibit number 2, the photograph, to file that under seal with the transcript to protect the identity of the jurors that were wrongfully captured in the photograph. And with regard to court's exhibit 1, the cell phone, I'll ask the court reporter to take a photograph of the contents of court's exhibit 1 before I remand that back to the custody of the sheriff. All right, pursuant to my authority under OCGA 15-7-4A5, having found Sheila Holly guilty beyond a reasonable doubt of indirect criminal contempt, I order that she shall purge herself of this contempt by serving 3 days in confinement at the Gwinnett County Detention Center.
Motherfucker.
Ms. Holly will be immediately remanded to the custody of the Gwinnett County Sheriff's Office, and she will be released from custody on Saturday, August 19th at 11:30 a.m. The Sheriff's Department is hereby directed to maintain custody of Ms. Holly's cell phone, which was previously seized by the court on August 9th, until such time as Ms. Holly is released from custody on Saturday, August 19th.
Well, now we know this judge
Thereupon,
isn't kidding
the Sheriff's
around
Department shall
with
release and
her
return the cell
courtroom.
phone to Ms. Holly upon her release from the
If
detention center
another
on
trial
Saturday,
shows
August
up
19th.
in her court,
I need a few moments
I
to
want to
prepare
see
that
that
order
one.
for the sheriff to take both Ms. Holly into custody and to maintain possession of her cell phone. But that is the order of the court. Ms. Holly is remanded to the custody of the sheriff. That concludes this hearing. Thank you.
Yeah. No matter what her intention was, she took pictures of the jury, and that is one of the worst thing you can do in contempt of court thing. Okay.
It'll take me just a moment to.
Yeah, that was it. Okay, now we know what happens to Austin Ford and her mother. 10 years, probably with time served, and with 75% that he has to be in there, that's a bit over 6 years, plus 10 years probation. And the mother spends 3 days in jail for taking pictures of the jury. Yeah. That concludes this, unless Mr. Ford appeals the sentencing. That is up to him and his lawyer to discuss. I think it was a bit over the top, but considering this judge, I don't think there will be much luck with that, because if you appeal it, you might get more. So that was a very, very interesting trial, where, in my opinion, it was apparent that the victim ended herself. That the medical examiner leaned towards self-ending, but the prosecution was desperate for a conviction. Yeah, all right. Thank you all for showing up. Thank you all for staying with me for a bit over 2 hours, which was much longer than I anticipated. I will be sending you off to MLS Law Show. He is actually doing his own trial. Yeah, he was the attorney in a trial, and he is going to show that, and he is showing that, and has been so for quite a bit. So I will be sending you over to him so you can see that, because it is real funny to see him in action. All right, that's it for me. Like and subscribe on your way out if you haven't done it, and I will see you maybe later today with my opinions about the RICO trial in Georgia, because it is the same district attorney who is trying to indict Young Thug, a trial I follow and cover. It is the same district attorney who is now indicting Trump. So that will be interesting. Thank you all. GD, what question did you have? Since the judge has the picture of the sleeping juror, will she do something with that? I have no idea. I don't think so, because the trial is over. Sentencing is done. So nothing more to that. Okay. Now it's it. Thank you all. See you all later. Have a nice day. Hug your family. Unless your family is shit, then fuck them, and spend time with people you enjoy spending time with. Bye-bye.